The subject of this video is the FISA Court, and particularly the FISA Court as it relates to all of the business about Trump, Carter Page, the Russian lady, the rest of them. And so what I'm going to try to do is to go very quickly through this process and to make sense of it and to put it in a chronological format so that it can be understood. What caused me to be incensed about the process is a letter from to Devin Nunes regarding a request he made to the presiding judge, that is the chief judge of the FISA Court, one of 11 appointed members appointed by Chief Justice Roberts, unless there are a few holdovers from the prior Chief Justice. But Chief Justice Roberts is the current Chief Justice that appoints all of these people and appoints them not to have diversity, so that they are not supposed to be across the political spectrum. They're supposed to provide a consistent judging material, and they're supposed to be doing it in alignment with the United States Supreme Court and the laws of the Constitution. So the letter that incensed me is a letter from Rosemary Collyer, the presiding judge, to Congressman Devin Nunes. Devin Nunes, as most of you know, is the point man, or one of the point men, on this whole investigation around the dossier, the Steele dossier, the Trump investigation, the special investigator Mueller, and the rest of this, and whether or not there's any rationalization or justification for any of it. And one of the things that he has been doing consistently is making requests both to the Department of Justice and the FBI for them to provide documentation, which has been a very frustrating process, and for which we got the memo, and then there was a follow-up requesting that the redactions include 20 pages that don't have redactions on them, and everybody's sitting around waiting for those final 20 pages. But that's an aside. Nunes has also made requests to the court, and including to the FISA Court, which he is permitted to do, and he made a perfectly legitimate request, which is, send me a copy of the transcripts of the hearings that you had in the FISA Court regarding the FISA orders, the warrants for surveillance, which you issued under the 702 FISA warrants, in accordance with, as it relates to Manafort and Carter Page especially, but as it related to people coming and going through the Trump election campaign and then President-elect Trump. And the request then was a letter he sent in February of 18 requesting the transcripts, and here is the response, and it is an incredible response. The contents of it are incredible. So Nunes requests transcripts of relevant FISC hearings associated with matters described in the letter, which exist, and if so, provide copies to the committee. And the court responds, as you know, any transcripts would be classified. May be helpful for me to observe that. In a typical process of considering an application, we make no systematic, but in a typical process of considering an application, we make no systematic record of questions we ask or responses the government gives. So what we're saying is, what this chairman, the lead judge, the presiding judge of the FISC Court, is saying, we don't keep a transcript of what it is we do when there's an application for a FISA warrant. Now, in this situation, obviously the protocol of it is not something to which I am privy, and I suppose I could spend 43 hours trying to figure it out. But one anticipates that the documentation is all provided. There's a hearing before a judge. The judge asks all the pertinent questions with regard to whether or not there's probable cause, whether or not the basis for the FISA warrant is justified, whether the documents are all authenticated, whether the signatures are all had, and then the judge is supposed to make an independent determination based upon both the statements and documentation provided by the Department of Justice, and also affidavits, documentation, etc. provided to support and substantiate the request for the FISA warrant. It is not supposed to be a rubber stamp process, not at all. But nevertheless, let's look at whether or not it is. So I looked it up, and according to the process, there have been, let's for instance take 2016, which is the last year of the Obama rule, if rule is what is applicable. There were 1,485 requests for warrants, and 1,451 were granted. And there were only 34 that were not. In the next year, 2017, which is the first of the Trump years, there were 1,372 requests made, and 948 of those were, excuse me, my nose itches. 948 of those requests were approved, which means that there were 428 requests turned down. That's about a 30% turn down rate. And it is a very high rate compared with all of the previous years, where on average only 0 or 1 or 2 or 4 or 5 requests were turned down. So it is a huge change. So let's go to why it is that we have warrants at all. And it is a very important question, and what I need to do is give you a brief historical context by which we come to it. In the colonial period, since the king ruled, and anybody who ruled the colonies ruled at the pleasure of the king, if the king or one of his minions requested information from somebody, they could literally come and search your house, ransack your house, and then go away. And if they wanted to do it to harass you, they could do it at will, and they could do it daily. They could do it often. They could look for whatever they wanted to look for. And so our founding fathers, as part of the Bill of Rights, said that cannot happen anymore. And so the Fourth Amendment says, and let me read it to you, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So in the classical sense, if they were looking for a drug transaction, and they had reason to believe, that is the police, the sheriff's department, the tobacco and firearms, alcohol, tobacco and firearms guys, or the drug enforcement folks, if they had reason to believe there was a transaction that was being undertaken, and they had reason to believe that the drugs had been dropped at some place, they would go get a search warrant. They would have an affidavit that would establish by oath or affirmation probable cause from an informant or from an investigating officer or from somebody who delivered it, or from an arrest that had been previously made, saying there was a drug shipment, and this drug shipment is amount of such and such, and it should be whatever these kinds of drugs are, and they should be found at residence of such and such, owned by so and so, and that they should be found on date, whatever that date is. And on that basis, a warrant would be issued if it showed probable cause that a crime had been committed or was about to be committed. And the officers then could take that warrant and gain access to that home in accordance with the Fourth Amendment, okay? What we've done with the FISA Court stuff, the FISA courts, and the FISA warrants is we've said, well, we need to know we need to know where we have probable cause, how to gain surveillance of electronic transmission of documents, etc., conversations, and we have to do that electronically and across a period of time, and we're going to still meet those constitutional standards. That's the idea. And so the FISA Court was set up to raise the bar, because obviously if you're not going to make a one-time warrant for one-time surveillance of an individual item or set of items or documents, and you're actually looking at, you're going to put a safe or a net out, a fishing net out, and you're going to look with that net to see whatever it is you can scoop up. What the constitutional requirements are and what the courts have determined is we make that fit even tighter. It has to meet a very tight standard to meet the probable cause requirement, because it is a more general application of our search. And so what we've done in the comparison of these documents is to look at 3 different kinds of warrants for electronic surveillance. And the typical federal one, which would include drug transactions that might occur between somebody that was shipping drugs and they wanted to listen to the conversations about one of the people that was organizing it, or that never touched the drugs but was the kingpin in making sure that they got from Houston to Chicago, they would get a warrant, again with probable cause, on the basis of information that they had obtained, and they would go to the federal court. They would use 18 U.S.C. 2510 et sec, and they would get warranted authorization for a wiretap, and they would wiretap that person's phones, or perhaps a set of phones, or perhaps all of the phones at a location, cell phones, and perhaps a couple other phones that the person might use. But there has to be somebody that's independent of the process that decides on it. It requires a federal or state judge to issue the warrant. They have to have targets for the location, the identification, the timetable, what they're looking for, and a reasonable idea of what they expect to find. All right, so, and it still meets the requirement of probable cause. Now, above that is a FISA Title I, a targeted foreign intelligence warrant, which allows for discrete wiretapping of communications to or from a target. And it is a specified target for a specified period of time. It requires the approval of the Attorney General as well as the FISA Court judge, and it required in accordance with 50 U.S.C. 1804. And then the foreign powers or agents of the foreign powers are included within that who can be targeted. They have to be foreign powers or agents of foreign powers located inside the United States. And that includes that. And again, it requires probable cause. And finally, there is a Section 702 FISA warrant, which is a large-scale foreign intelligence warrant according to 50 U.S.C. 1881A. And that warrant allows for a broader net. It still requires the probable cause, and in order to meet those requirements, the way it was set up was that it requires the Attorney General, the Director of National Intelligence, and others to approve it, and the 4 signatures that Q keeps pointing out have to be there, had to be on every one of those requests, those applications for a warrant, and they all had to pass on the fact that they saw probable cause and that their sources were genuine and that they had given complete and adequate and non-contradictory information to the court in order for it to make a determination. Those statements in there are sworn statements, and they're statements made both to the court, and they are subject to perjury or false statement to a court. They are subject to a federal criminal process if in fact they are lying to the court or materially misdirecting the court or misleading the court as to what the contents are. And the Carter Page stuff in particular and the Steele dossier stuff in particular there are serious problems with it. And Nunes and the rest of the folks have gotten to the bottom of it. And it breaks down the probable cause, and once it breaks down the probable cause, it breaks down the whole warrant process, the whole surveillance process, and anything that is associated or drawn into the surveillance process. So they took, for instance, with Carter Page, they took a tenuous, invalid process with a guy that they already knew, that was an insider, that was an asset, that was an FBI asset, that had been used as an FBI witness, that had been used to prosecute Russian individuals for other violations, and they flipped him, according to the way they approached the FISA court, did not, as I understand it, disclose that he was in fact an FBI asset, excuse me, flipped him, or a CIA asset, flipped him, and then said that they thought he was working as a foreign Russian agent and that he was transporting information back and forth to Trump in an illegal sort of way. And that by doing that, and with the Steele dossier, they justified and rationalized that Carter Page was going to have access to Trump and that Carter Page would be the source of the problems. And so they bootstrapped a bootstrap of a bootstrap. And then, knowing full well that the Orrs, Bruce and Nellie Orr, were backdooring this stuff, taking it from Fusion GPS, lining up the Steele dossier, manufacturing it, that it was incorrect, they put it into the affidavits and put the process, the request for the warrant in, and then they, in order to validate, to separately validate it, first of all, they're supposed to validate it according to the source, which would be sources that would be linked to Carter Page or to the Steele dossier, both of which were tainted. Okay. Secondly, they're supposed to triangulate this and say that they've gotten this information from alternate sources that also validate it. And in that case, they triangulated that process by using Steele in multiple settings with other reporters that all said the same thing from the same source. And so instead of having multiple sources to validate and verify what they're asking for, they did not. And thirdly, they went, then they signed it, and they signed it, many of them, of the four individuals, knowing, and Carter and Priestap and Strzok and Orr and who else? Comey, all knew that, or at least I believe that they all knew, that this stuff was trumped up, no pun intended. And then they took it to a FISA court, and then the FISA court ruled on it, rubber stamped it 4 different times, and made no transcript or record of it, even though this is a highly defined, carefully structured warranting process according to the United States Constitution, and in this case, against one of the 2 final presidential candidates and the president-elect of the United States. So they still didn't take a transcript of it? I don't believe that. I believe they did it. I can't believe they did it, and I can't believe how they did it. So this whole process is so very fishy and so out of alignment with our whole constitutional underpinning that it violates the sniff test in the most fundamental way. All right, so let me look at some of the other processes through this. So to get back to it, here we are with all of these people supposedly approving this warrant. All of the source material of this warrant is supposed to be valid. Everything has been manufactured, trumped up, and played with, and then run through these 4 guys that are all supposed to sign off on it, and then taking it to the FISA court that did not properly review it or inquire about it, even though they asked for and obtained a warrant 4 different times. Now, the second or third time that you went in for the warrant and you had gotten nothing before, if you were a discerning judge, would that not cause you to say, well, are we really looking for the right thing? This has been going on for a year now. Are we really looking for the right thing? And tell me why it is you think you're going to find it this third time if you haven't found it already. And that was not only a perfectly legitimate question, it would be crazy not to ask that question, and why it is that they had gotten additional information or more validating information which would justify continuing the warrant, because it should go under extreme scrutiny from the start and more scrutiny as you proceed, okay? So this is basically, let me take a look at the Q business and see if there's anything else that ties into this. But the whole idea of the FISA Court is a critical process, and failing rationalizing this process in a legitimate way according to the Fourth Amendment, this whole thing falls apart. And nothing that they've obtained from this Veselnitskaya or from Page or from anybody else that was part of the surveillance is justified. Now, let me go one step further and describe to you why this 702 warrant is different. What they do with the 702 warrant, and this is something that's pointed out by 2042 not very well, but the idea is that what the 702 warrant says is you can check emails from this person and emails to this person, okay? Now that's fairly confined. What you can also do, however, and that's part of the problem and process of this, is that the net gets bigger. And the reason that the net gets bigger is because they start to draw in anything that relates to that person, and therefore they go after anything that relates to that person's email address, if that's the one. So theoretically, they could go for anything that is mailed to x@gmail.com, anything mailed from x@gmail.com, but they also can go after anything, any document out of millions and billions of documents that have x@gmail.com in the content of them somewhere. So they could look for everything to or from or everything about. And everything about is now, the fishnet has gone out. They're not plunking this over a hole in the pond. They're plunking it over the entire pond and looking for every fish that might be talking about the one little goldfish in the pond. And so it is a huge process, and what Q points out is that this is a bulk data collection, which it is. Look for anything that you want to look for that relates to that person, that ties that name in. And of course, the NSA says, well, we don't have a perfect way of doing this, so we have to look at everybody. Well, I don't believe that. You and I both know, we know this from Walmart and everybody else, they know precisely what is going to and from each of us, and they know precisely how to track it, and they have simultaneous tracking. I mean, you can't buy a pack of napkins at some place in town and get home and not have napkins on the side of your email stuff, of your video stuff on your YouTube or others that doesn't have napkins in it. If it's tied to your debit card, they have it before you get home. So this thing is all just a big game, and of course it shows the seriousness of the violations and the intent to misuse the process, much as they misused the IRS investigations for conservatives and for conservative nonprofits and for individuals, much like they've targeted them. If you want to listen to a similar kind of process, listen to Dave Janda and what they did to him as part of his IRS audit that took 8 or 10 months, and what they asked for, which is crazy stuff. So let me take one last look and see if there's anything else about this FISA business. The DOJ admitted, and this has to do with Carter Page, that the FISA Court held no hearings on the FISA spy applications targeting Carter Page. So not only did they not have a transcript of it, they didn't do a hearing. They rubber stamped it. And they did it 4 different times. So we have 11 judges appointed by Justice Roberts that are overseeing this entire highly critical, highly contained, difficult to maintain constitutional validity court system. And we have 11 judges in on that, looking at 1,300 or 1,400 of them a year, and they don't have a hearing. They don't have a hearing the first time, the second time, the third time, or the fourth time, and they don't have a hearing regarding the president-elect, people engaged supposedly with the president-elect, the presidential candidate and president-elect. That's crazy stuff. So Judicial Watch has picked up a bunch of this. I want to also point out to you that just came in, and I have not had a chance to really look at it in any depth, but there is a list, the FOIA state search results that were sent having to do with emails to and from Hillary Clinton, and there are 20-odd thousand of them listed, so it will give you plenty to look at if you'd like to take a look. And finally, the last posting, which is 2047, I'll just close out with this. Saudi Arabia, what Q is going through this, saying Saudi Arabia cleared, Epstein Island cleared, Haiti cleared, closed, North Korea closed, China closed, Russia closed, Cuba closed, Sudan pending, Syria pending, Yemen pending, Libya pending, and Somalia pending. And I don't know where they're going to put Iran. And then it goes on to post, and that came from August 18th. Now we have Alice and Wonderland. Who are the white rabbits? Read the drops regarding Saudi Arabia. Have faith and forgotten country. So thank you so much for watching. I hope this helps to clear out the whole FISA business and to show why it is so suspect, on so many levels, right from the application process through the Department of Justice, through the FBI, through the FISA Court, and then by application. So thank you so much for watching. Hope this has been edifying. And if you like it, give a thumbs up. And I will be taking a look at some of the other stuff. But this is pretty crazy stuff. Thanks.